In 1945, the world put Nazi leaders on trial at Nuremberg. But what were they guilty of? Many of the horrifying acts that they had committed were perfectly legal under German law at the time. The prosecutors had to make a revolutionary argument that there is a higher law, a law of humanity, that no government and no leader can violate. Nazi leaders were tried under new categories like crimes against humanity, which had little precedent in international law, and which challenged the idea that states could shield atrocities behind domestic legality. That single radical idea that what a state does to its own people is not just a domestic matter, but the world's business, became a spark that ignited the modern human rights movement. The very idea that human rights are universal, that they exist above and beyond any one state's authority, didn't begin at Nuremberg, but the trials gave it unprecedented urgency and visibility. Its philosophical roots go back much further. Enlightenment thinkers like John Locke and Jean-Jacques Rousseau argued that individuals have natural rights that no ruler can legitimately take away. Movements to abolish slavery, campaigns for women's suffrage, and early labor rights struggles also helped expand the notion that rights are not privileges granted by rulers, but entitlements inherent to all people. Still, for much of modern history, states claimed near absolute sovereignty, the idea that what happens inside a country's borders was its own business. That's why the Nuremberg prosecutors' argument was so revolutionary. It directly challenged that principle. They insisted that crimes like genocide and crimes against humanity were violations of an international moral and legal order, even if they were under domestic law. The shock of World War II and the Holocaust gave this argument extraordinary force. As the war ended, leaders recognized that peace and security could not be separated from how states treated their own citizens. That conviction found its way into the UN Charter of 1945, which, for the first time, embedded human rights as a central purpose in the international system. Just 3 years later, in 1948, the world took a further step with the adoption of the Universal Declaration of Human Rights. Drafted under the leadership of Eleanor Roosevelt, the UDHR laid out a common standard of achievement for all peoples and nations. While it was not legally binding, it nevertheless became a cornerstone of the modern human rights regime, inspiring treaties, national conventions, and countless advocacy movements. The Cold War revealed divisions over what rights mattered most. The West emphasized civil and political rights like free speech, free elections, and due process, while the socialist bloc stressed the economic and social rights like the right to work, housing, and healthcare. This ideological split led to the creation of two major treaties in 1966. The International Covenant on Civil and Political Rights reflects the liberal democratic tradition that prioritizes individual freedoms and protections from state abuse. It guarantees rights like freedom of speech, religion, and assembly, the right to vote and participate in government, and protections for due process, fair trials, and the freedom from torture or arbitrary detention. These are often called negative rights because they emphasize limits on state power, defining what states cannot do and maintaining protections for certain fundamental freedoms. By contrast, the International Covenant on Economic, Social, and Cultural Rights emphasizes the rights necessary to ensure human dignity through material well-being and social participation. It recognizes the rights to work, education, healthcare, housing, food, and social security, as well as cultural rights. These are sometimes called positive rights because they require states to take proactive steps to fulfill them, defining what the states must provide for its people by, for example, providing resources, services, or policies. The ICESCR thus reflects the socialist and post-colonial view that true human freedom requires not just political liberties, but also economic and social justice. Together with the UDHR, the two international covenants are often referred to as the International Bill of Human Rights. From the Universal Declaration in 1948 through the Twin Covenants of 1966, a dense web of treaties and institutions gradually developed to promote and protect human rights. Together, these form what we often refer to as the international human rights regime. At its core are a set of multilateral treaties that define and codify rights. Beyond the ICCPR and the ICESCR, additional covenants prohibit specific abuses, like the 1948 Convention on the Prevention and Punishment of Genocide, the 1979 Convention on Elimination of All Forms of Discrimination Against Women, and the Covenant on the Rights of the Child of 1989. All told, there are more than a dozen major human rights treaties, each monitored by its own treaty body of independent experts who review state reports and issue recommendations. Within the UN system, the most visible body is the Human Rights Council, created in 2006 to replace the old Commission on Human Rights. Its most innovative tool is the Universal Periodic Review, where every UN member state record, even those of the P5 or other powerful states, is scrutinized by its peers. Critics argue that the Council is highly politicized. After all, some of the world's worst violators hold seats. But it at least has institutionalized regular scrutiny of all governments, large and small. The Office of the High Commissioner for Human Rights was established in 1993 to provide technical support, monitoring, and advocacy. Though underfunded and often reliant on member state cooperation, the High Commissioner serves as the UN's leading voice on human rights issues, bringing visibility to crises that might otherwise be ignored. And beyond the United Nations, regional human rights systems have developed in Europe, the Americas, and Africa. For example, the European Court of Human Rights has issued binding rulings on governments from Russia to the United Kingdom. The Inter-American Court of Human Rights has held states like Guatemala and Colombia accountable for abuses. And the African Court on Human and People's Rights, though weaker, represents an important regional commitment to rights protection. Taken together, these treaties, bodies, and institutions make human rights one of the most institutionalized areas of global governance, creating, for the first time, a comprehensive vision of rights that applied, in principle, to everyone, everywhere. While these institutions and treaties matter, much of the power of human rights comes not from formal enforcement, but from norms, the shared understandings of what is acceptable and legitimate behavior. The Universal Declaration of Human Rights is a perfect example. It was never intended to be legally binding, yet it's become a kind of moral constitution for the international community. Governments cite it, activists use it to pressure their leaders, and courts often treat it as evidence of customary international law. Its authority comes less from coercion than from the weight of global consensus. Human rights norms also shape behavior by creating what scholars call a logic of appropriateness. The idea is that states don't just do what is useful, they do what seems legitimate and proper. Even governments accused of torture or repression rarely admit it outright. Instead, they deny allegations, redefine their actions, or claim exemptions. The fact that states feel compelled to justify themselves show how deeply embedded the norm has become. Indeed, some of the most striking victories in human rights have been norm-driven. The global campaign to ban landmines show how advocacy and treaty-making work together. In the 1990s, NGOs and sympathetic states pushed hard to stigmatize anti-personnel landmines, arguing that they caused indiscriminate harm to civilians long after conflicts ended. Their efforts led to the Ottawa Treaty of 1997, which bans landmines and was adopted by more than 160 countries. Even states that haven't signed it, including the United States, Russia, and China, have sharply reduced their trade of the weapon, reflecting the power of international stigma and the practical difficulties of deploying a weapon that most of the world has outlawed. Similarly, the norm against torture, while frequently violated, is so powerful that almost no government defends torture openly as legitimate policy. In this way, human rights norms act as a kind of soft law. They may not have the binding force of treaties or the backing of courts, but they create powerful expectations. They shape diplomacy, influence public opinion, and provide common standards that states ignore at real reputational costs. And that raises the next big question. If so much of human rights law depends on norms and reputation rather than force, why do states actually comply? Human rights are among the most ambitious promises of global governance, but they're also among the hardest to enforce. Let's look at both the successes and the limits. On the success side, global pressure and institutional tools have mattered. The campaign against apartheid in South Africa combined grassroots activism, international sanctions, and UN resolutions to delegitimize the regime and eventually to help bring it down. The arrest of Augusto Pinochet in London in 1998 showed that former leaders accused of crimes against humanity could be held accountable abroad under the principle of universal jurisdiction, the idea that some crimes are so serious that any court, anywhere, has the authority to prosecute them. And more broadly, human rights language now permeates diplomacy, development aid, and public debate. States and leaders are routinely called out for abuses in ways that were rare just a few decades ago. But the limits are equally clear. Enforcement is often selective. In 2011, the Security Council invoked the Responsibility to Protect doctrine to justify intervention in Libya. Yet, when similar atrocities were committed in Syria, great power divisions paralyzed the Council and R2P was left on the sidelines. Powerful states are rarely held to account. The United States, China, and Russia, all permanent members of the UN Security Council, have largely shielded themselves and their allies from meaningful scrutiny. And the Human Rights Council itself has been criticized for politicization, with states accused of serious abuses serving as members and using the platform to deflect criticism. These examples reveal a central tension in global politics: sovereignty versus universality. On paper, human rights are universal, but in practice, states often guard their sovereignty fiercely and reject outside interference in what they claim are domestic affairs. So, while human rights norms are powerful, enforcement depends on political will. Where interests align, international institutions can act decisively. When they don't, human rights commitments often fall short. And that tension leaves us with an important lesson. Human rights illustrate both the promise and the contradictions of global governance itself. Let's return to where we started, the Nuremberg trials. There, the prosecutors argued that there exists a higher law, a law of humanity, that no state and no leader can violate with impunity. That radical idea led the foundation for today's global human rights regime. Since then, human rights have been woven into the very fabric of global governance. They're codified in treaties, promoted by UN institutions, and embodied in powerful norms that shape what states see as legitimate behavior. At times, these tools have helped to bring down oppressive regimes, prosecute perpetrators, and given voice to the vulnerable. Yet, enforcement is inconsistent and selective, often shaped by power politics. Human rights highlights both the extraordinary ambition and the frustrating limits of global governance, a system that aspires to universality but still depends on the political will of sovereign states. And that brings us to a bigger question. If something as universal as human rights can become politicized and contested, what does that mean for the future of global governance as a whole? Let me know your thoughts in the comment section below, and I'll see you in the next video.